corner here had something to do with asking Kim to do that. And I suspect it has a lot to do with the fact that she has been sick and tired of me pontificating about the subject of local government powers for the last few years, and she wanted to share her pain with the rest of you today. To be honest with you, though, I am somewhat in awe of being in the presence of a number of the delegates, many of whom have become good friends over the years: Arlene Reichert, Bob Campbell, Bob Woodmansey. But I do want to share with you a quick little story about your success, and I don't want it to go to your head too much. In 1971, Montana had the opportunity for the first time to share in a great program that had been sponsored by the YMCAs nationally for many years, called Youth in Government. And the principal design of that program was to bring high school students together in their respective state capitals and conduct a mock legislature. And in 1971, the YMCA brought that program to Montana, and they had their first mock legislature in 1971. But in anticipation of the fact that we were going to have a constitutional convention, the adult advisors thought it would be a good idea to have a youth constitutional convention sometime in 1972. And I was finishing up high school at that time, and I was privileged to be involved in that youth con-con. We met a few days before the start of the regular convention. I'm happy to say that we wrote our document in 4 days, and it's virtually identical to the one that it took you over 50 days. So I don't know what that says about the power of youth. But before I begin today, I do want to acknowledge some folks who helped me put my portion of the program together today. As an elected city officer, I'm very happy to be a member of the Montana League of Cities and Towns and sit on their board of directors. So I've had the opportunity to commiserate with Alec Hansen, the executive director, my friend Jim Nugent, the city attorney in Missoula, who's really the dean of, I think, city attorneys now on the subjects I'm going to talk about, and also my good friend Jay Duncan, who is the mayor of Choteau. And they've been very generous in their time in sharing some insights with me, and hopefully I will be channeling some of their thoughts today. For my 15 minutes, what I'm going to do is focus primarily on 3 things. One, I'd like to give you a brief overview of how self-governing powers have worked in practice. Second, I want to discuss with you briefly whether or not the full promise of Article 11 has been realized with respect to local government, and I'm going to suggest to you that it has not. And although we've made some tremendous strides, we have a long way to go. And finally, as any lawyer would appreciate when they have a chance to speak in a forum like this, I get to pick on the Montana Supreme Court a little bit today. But when I do, I will utilize a disclaimer, much as Judge McNeil used here, to protect myself from their powers. Again, well, you're going to love it too, trust me. First and foremost, though, I want to share with you my belief, as I think Jim and Dan share, that Article 11 was probably one of the best articles that was drafted. And as a result of it, we in the cities and towns primarily have had the opportunity to instigate a lot of important reforms that I think have benefited the overall operation of municipalities in this state. I'm going to draw on a few personal examples here just to, I think, illustrate my point. The city of Great Falls in 1986 adopted a charter. We, in essence, have our own constitution for the city of Great Falls. And by virtue of adopting a charter, we have self-governing powers. Jim talked to you a little bit about the Dillon Rule. It's a complete flip-flop and reversal with us. We now have all powers except those that are specifically withheld from us under the Constitution, statute, or even our own charter. In 2005, I chaired the City-County Planning Board in our area. We had city-county joint planning for almost 40 years. For reasons that still befuddle me, the County Commission in 2005 decided that they no longer wanted to be part of a joint county-city planning effort. And they wanted to dissolve the City-County Planning Board, which led to an interesting little and heated exchange between myself and a certain county commissioner who I will not name. But they have the power to do that, and reality being like it is, the city of Great Falls was confronted with having to create a city planning board strictly overseeing zoning and planning activities within the city of Great Falls. The city attorney at the time and the city manager and I looked at the statute, however, dealing with how you set up a city planning board, and it's safe to say we said, oh my God. The statute was adopted in 1957. It's extremely archaic. It was written, I hate to say, before the days that we had a legislative council that helps our legislature draft legislation. And in the statute it authorizes or tells you how a city can set up a planning board. It says that one of your appointees has to be designated by the county commission. Well, as you can imagine, given what had led to the demise of city-county planning, we were not interested in having the county have any involvement in city planning affairs. Not that they would have been interested, but then we realized that we are a self-governing authority. The charter of the City of Great Falls provides that the City Commission may create such advisory boards and commissions as it deems necessary to assist the city in performing its duties. We determined that we have a duty to perform planning and zoning activities, and it was our consensus that under the charter we had the authority to define what type of planning board we would set up, what its membership would be, and how it would function in advising the city in carrying out those duties. And that's what we did. It has not been challenged, and it has been there ever since. More recently, some of you have probably heard about the interest that some local governments have had in adopting ordinances dealing with cell phone use and texting while driving. Some local governments have already adopted ordinances to that effect. We in Great Falls will be considering one here very shortly. That's an example of a community with self-governing powers being able to make that decision on its own without having to run to a legislature that only meets once every 2 years to tell us how to resolve our particular problems with that issue. And there are many other examples that have been put into practice, and I won't go through all of them in the interest of time. But we have the right to operate drug and alcohol treatment programs. We can impose fees for future expansion of water and sewer systems. We can require residents to connect to city water utilities, and the list goes on. And for the most part, I think the use has been very effective and very wise. But as I said at the outset, the second thing that I wanted to mention to you is that I do not think we have yet fully gained the full measure of what Article 11 provides to us. And there's a number of different instances where I think we have failed, but the primary one has been with the legislature and its withholding of the power to local governments to deal with taxation. A Montana Code Annotated 71112 sub 1 says that we, as self-governing powers, do not have the power to levy local taxes on our own. We must obtain that authority with respect to income or sales taxes from the legislature. Now, I recognize, and I read the transcripts of the discussions about the local government article, and I fully acknowledge that there was some discussion amongst some of the delegates about whether the power to tax might be one of those that would be withheld or at least conditioned by the legislature. But to pull from Justice Nelson's comments yesterday that when you're looking at it from a legal standpoint, it's better to work with the plain text of the language with which you're given. I don't see anything in Article 11 which specifically withholds that power. And more importantly, as a local government official, I can tell you that the power to tax is fundamental to the exercise of government powers. If you deny it or if you limit it, you constrain local government in its ability to be flexible and to be accountable, which is, I think, the ultimate goal or mission that was announced by the convention delegates in 1972. We rely in local government solely, for the most part, solely on the property tax, which is a very inefficient tax. It's very limiting. It's subject to too many state mandates, and it does not really allow us to address a lot of the concerns that we have in local communities. The legislature has granted this power of taxation to what it calls resort communities. But the question I've always asked is, are not the major cities and towns also resort communities? We deal with large numbers of tourists every year. We promote tourism in these communities. And yet we lack the power that is given to some of the smallest communities population-wise in the state. It's a fundamental problem and it needs to be resolved. But more importantly, perhaps, there's another issue too, and that has been that over the years, the legislature has at times cut back on the power of local governments to exercise authorities in areas that, again, from a local government official's perspective, I think are properly theirs. My friend Jim Nugent reminded me of a good example of this about 10 years ago, when the city of Missoula attempted to enact a licensing program for landlords in their community to deal with a unique problem that residents in Missoula had, trying to keep track of who was a landlord and how the city might then be able to allow law enforcement and city government to address problems. What happened? In 2001, state landlord organizations went to the legislature and convinced the legislature to adopt another provision in powers that are denied to local governments, stating that local governments did not have the power to license or regulate certain activities of landlords. And they've done some other ones too. We're limited in ordinances that we can pass in the area of vagrancy. There's another real interesting one that tells us we can't regulate fertilizers, and I'm not really sure what prompted that one. But in the last session of the legislature, there was another attempt to deal with this issue as well. It did not succeed, but I mention it because it is of great interest to a lot of folks. And that was House Bill 516, which would have disallowed local ordinances extending certain human rights protections beyond those classes that are protected by state law. It was clearly an effort to overturn Missoula's decision to adopt an ordinance addressing what it felt were issues of discrimination in the lesbian and gay community. Now, we had a lot of discussion about this ordinance at the level of the League of Cities and Towns. And it was interesting because we were told that, well, the legislature has to step in because really local governments don't have that power anyway. Well, they most certainly do. If you read the Constitution and if you read the provisions of state law, they clearly have that power to make that decision. We also heard arguments that, well, this statute doesn't protect due process rights, to which the response was, well, it certainly did, but if there's any question whether it does, number one, our courts are there to address that issue, and two, if it isn't, leave it up to the people of Missoula and their elected representatives to solve that problem on their own. We don't need the guidance of the legislature in order to resolve that. The point is not whether or not Missoula should or should not have adopted that ordinance in the first place. The point is it was within their power to do that. And finally, just briefly, a few comments about how the Supreme Court has dealt with this issue. And I intend here to invoke the protections of a grand principle that was taught to me by my friend and mentor, the late Justice John Harrison, rest his soul. A tremendous man, a great human being. We just lost him recently. But he taught me a valuable lesson about 30 years ago when I was clerking at the Supreme Court. And he said, Bill, if you don't like a decision of this court, you can call me up anytime and you've got one free gripe. Call me a second time and it's contempt.